Hey y'all. All right, so the revocations have begun. They have begun. All right. So the state of Georgia versus Antonio Sledge. Antonio Sledge is Mounk Tounk, for those of you who don't know his government name. The state is petitioning and motioning to revoke his probation. And we kind of knew that this was going to come based on his testimony. It was not what Attorney Love wanted from him. And I think that we all agree now that, when someone is going against her, she's going to do everything in her power to get her league back. Okay, so let's read through this a little bit just to kind of understand. Okay, I won't read the first part where it says states motion and petition to revoke probation. It's exactly what it says, that they're motioning to revoke his probation. All right, so number one, plea of guilty by the defendant on December 28th, 2022. And we heard a lot of this during his testimony in the trial here recently, that he took a plea deal and he was given 30 years of probation. He told us that he was trying to get home to his sick mother, so he took the plea deal. He did mention that some of the things, acknowledgments in the plea deal, he did not actually agree with, and he asked if she could change some things. I think she might have changed a couple of things here and there, but not really. The emails between her and Attorney Wright showed us that those things were asked for. She just didn't do it on the final copy. He apologized. He should have looked it over. He did not. So here we are. So on December 28, 2022, the defendant pleaded guilty to conspiracy to violate the Racketeer Influence and Corrupt Organizations Act and possession of a firearm by a convicted felon. Chief Judge Uriel Glanville subsequently sentenced him to 30 years of probation. That's crazy. The general and special conditions of probation were detailed in the final disposition sentencing sheet filed on that date. Whew. Let's see. So basically, in his plea agreement, these letters here that you see, A through D, it's basically saying that the defendant has to acknowledge what he signed in this plea agreement on the stand. That's basically what that's saying in short. All right, the defendant has violated all the special conditions of his sentence outlined above. She's saying he has violated each and every special condition. On September 4th, 2024, he was called to testify in the trial of this case, with his testimony continuing through September 6th, during which he underwent both direct and cross-examination. During his testimony, the defendant directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he had sworn were accurate and true during the plea hearing on December 28, 2022. She says that at the time he had the opportunity to correct or clarify any statements. Now remember, he said that a few times on the stand, that she told him, don't worry about it. When you get on the stand, you can clarify anything. You have to be careful what you sign. Because he signed it, she's holding him to that. Although she probably did verbally tell him that. She doesn't have to uphold it, though, because it's not in writing. Here's the part that gets me. It is evident that the defendant knowingly and willfully violated the special conditions of his negotiated plea agreement with the intent to disrupt the trial of this case. I don't think anybody is trying to disrupt the case. Everybody wants this case to be over. Did he get up there and acknowledge every single statement. He did not. But those statements that he did not acknowledge were talked about, and he told her that he didn't acknowledge them at that time. But she convinced him that she will allow him to clarify, and she did not. Hopefully, Judge Whitaker gets this one right and does not sentence this man to 30 years in prison, to the remaining 30 years in prison. I hope she gets this one right. I hope she gets it right. To sentence someone to prison because you feel like that his truth is not the truth. I hope she get it right.